So I want to start with this observation that because the topic is new, most of the conversation and debates nowadays on algorithmic collusion take place at a very abstract level. There are typically at the in-principle level of discussion whether or not algorithmic collusion is at all possible. And people are engaged in modeling of this phenomenon in order to basically to demonstrate that it is or it is not possible, and so on. So one of the very first questions that would come up with regard to this topic is how realistic is it for algorithms to collude? What is the likelihood? And if it is likely, then what should competition law do about this? So that's I think, in my mind, that's the very first and most basic question about algorithmic collusion. Once you do that, then the set of legal issues come up, starting with the very language of competition law. In terms of, for instance, in current law, the terms that are typically used in talking about collusion between firms are things such as the meeting of minds, mutual understanding, conscious commitment to a common scheme, and so on and so forth. And these phrases, this language takes on a whole different meaning when you apply them to machines. What does it mean for computers, for instance, to meet mentally? What is the meaning of meeting of minds for computers? What does it mean for computers to understand each other? What does it mean for computers to communicate with each other? What does it mean for computers to be conscious at all? What does that even imply, right? So that's the most basic. These are, as you notice, these are mostly or as much philosophical questions as they are legal questions. That by itself turns the debate into a very intellectually challenging and interesting debate, thinking about these questions of language and basic concepts of collusion. But more directly to law, there's the issues of evidentiary standards. So where should we set the bar when it comes to evidentiary standards, when it comes to computers? What does it mean, for instance, for computers to expressly coordinate with each other? Or what does it mean for them to, if you use exclusively the price as a mechanism, as a standard, then is that going to be too low a bar? So you can set the bar high or low if you apply the same standards that we've been applying to firms so far. In terms of remedy, let me actually, before talking about remedies, also point out that there are economic questions, such as, for instance, what kinds of market arrangements facilitate collusion, or what types of product structures facilitate collusion. These are also important questions that you find people debating within competition law, but also among economists. Or yet another set of questions which are technical in nature, because many of these computer pricing models and systems use some technology that has been around for about 30 years, 40 years. Many of you have heard about neural networks, and nowadays, a new version of that is deep learning and so on. So these networks, just very, very quickly, I have to mention for those of you who are not familiar with this, have this characteristic: they do not work on a rule-based basis. Unlike traditional programs and software, they are supposed to operate like human brains, in the sense that they discover patterns in a way that the human programmer or human user might not be able to understand. So the system, the machine, identifies things. In this case, in the case of collusion, for instance, if you put two software programs together and they can communicate, one scanning the pricing of the other, the behavior of the other, they might discover things in each other's behavior, but the human observer, whether it is an engineer or a judge, doesn't matter, right? They might not be able to discern what is going on, on what basis was this communication happening. And that creates a huge technical problem. And it is important because, now I want to actually segue to remedies, because some people are suggesting that we have to do an algorithmic inspection in order to basically to identify anti-competitive behavior. That's a nice idea, but not very realistic, given what I just said a minute ago, because algorithmic inspection means that you are going to be able to sit down and go through the algorithm and decide whether or not there's something illegal going on here. But how can you do that when you do not understand the behavior of the system? So algorithmic inspection, while very appealing to some people, including myself, is not the most promising direction, for instance, for competition law to deal with algorithmic collusion. Or some people have suggested per se prohibition. Harrington, this antitrust lawyer in Florida, basically suggests that once we have discovered through inspection what types of algorithms might lead to collusion, we can just prohibit them per se and then leave it at that. But that is based on the premise that algorithmic inspection is possible. And as I said, some people have doubts about this. The other one is to make algorithms transparent. That's another approach, right? But transparency is a double-edged sword, because while it can benefit consumers, it can also enhance coordination among competitors. So, this is like the famous case of, two, gas stations in a small town, one reading the price of the other on the board, right? Without conversing with each other, talking to each other, you can imagine they can easily adjust their prices. This is the equivalent. Once you make things transparent and algorithms can see each other, you might create actually more opportunity for collusion than the opposite. So these are some of the questions and challenges that people are facing in law and in economics and in technology, essentially, in thinking about algorithmic collusion. And I wanted to use just a couple of minutes to set this, the tone and the questions up. And we have a very good, amazing group of experts who can comment on these and other questions, of course, starting with Professor Giacomo Calzolari, who is a professor of economics at the European University Institute in Florence, Italy.
So thanks a lot. And let me really thank the organizers of this meeting. I'm very happy to be here. A special thank to Maksim, that was very helpful in having me here. I had some troubles in organizing my trip, but finally here we are. So I'm an economist. I'm actually, I would say, a theoretical economist. So I normally do some abstract models, but I also like to really move and have some activities on practical activities. I want to see my research useful for actual market, real policy issues, and I'm also collaborating with the European Commission in a group of experts on competition policy. This is just to say that I'm a theorist, but also like really working on applied topics, which is what I'm going to talk about today. I will start telling you about what we did with a group of colleagues. We started to work on the idea of algorithmic collusion a few years ago. But before we go on that, let me just start with a few preliminary statements, because this research that we have been working on has been taken up by the media. The topic is catchy, we know. And some of the reports by the media have been a little bit stretching what we are actually showing with this research. So first of all, I'm not against artificial intelligence and the use of it in markets. I think this is going to be a dramatic new industrial revolution. I bet on that. So I'm not showing that algorithms are already colluding in markets. And you will see that we use a different approach. What we have done is actually a proof of concept. We show that this is a real issue, and it makes sense to spend some time to discuss together. And I'm also not against the possibility that AI-powered algorithm learn to cooperate. Cooperation is an essential ingredient in the functioning of our society, of markets. Think about self-driving or autonomous cars, and having cars that do not cooperate, these type of cars that do not cooperate in the street is going to be very dangerous for us humans and almost impossible to manage. We do need that artificial intelligence solves this issue of cooperation. Now, there are good type of cooperations and bad type of cooperation. Cooperation on prices normally is not a good type of cooperation. So what we did with these colleagues, we started a few years ago. We set up a virtual market with as many details as we could think about in order to have a very realistic representation of markets. We populated these markets with some standard consumers, virtual consumers, and on the other side, on the side of companies, firms, we populated it with artificially intelligent powered algorithms that were delegated the choice of prices in these markets. This is what we did. And so let me just tell you a few words about what we mean for autonomous algorithms. So the idea is that these algorithms are not instructed on how to behave and set prices in market, and they just autonomously learn this activity in markets. So if you try to open up a software, AI software that is designed for this purpose, what you would see in the software is essentially two instructions. The first instruction is you tell the algorithm what is the objective. For example, maximize profit of my firm. The second instruction is how to learn to do this activity, to reach this objective. Okay? So that's it, very simple. Well, it's not so simple because if you think about learning, it's really one of the high level capability of human beings or intelligent beings, how to learn to do something. Now, I will not enter into the details. I think it's a very interesting, also philosophical issue and discussion here. What is learning? And AI uses some types of learning approaches. What we have done, we powered our algorithms with one particular type of learning, which is called reinforcement learning, and in particular Q-learning, which is one of the most common approaches used for artificial intelligence in decision-making, where you use AI to take decisions, for example, to set prices in markets. By the way, this is a reality. Q-learning, the algorithms that we are using, are already in use in markets for price setting. I said price setting, not price fixing. Okay? So I'm not claiming that, as I said, collusion is already there. So there are large companies that are already using this type of algorithm, exactly the type of algorithm that we are using in order to set the prices for the products. I can make names, but let's go on. Now, let me spend a few words on this type of learning, the idea of learning that is behind these reinforcement or Q-learning algorithms. The idea is very simple. It's an idea based on the fact that if you want to learn to do something, you have to try. So it's a trial and error approach, essentially. So you have to instruct the algorithm to explore the environment. That's it. This is the only information you give to the algorithm. on top of maximizing some objective, like profit, for example. Now, exploring the environment, it's a tricky thing to do because if you want to maximize profit, you cannot just try forever the environment. So you must intelligently balance trying and exploring and at the same time exploiting the environment, or taking what the computer scientists call the greedy action, the action that really gives you the highest possible profit at that point. So learning that is done by these softwares is mediating, balancing this exploring and exploiting the environment. So that's it. It's not so complicated. So as I said, we took these algorithms and we studied their behavior in virtual markets. Now, before I show you the results that we obtained, let me just remind you what, so the notion of tacit collusion with the words of economists. I know there are differences, some differences between economists and lawyers. So the idea is that we have tacit collusion, or the idea of tacit collusion is that it's a rewards and punishment scheme that is not necessarily explicitly agreed by companies, by managers, and that in the end allows companies to keep prices at super competitive levels. So remember, it's not just high prices. It must be more than that. That's the idea. So what I'm going to show you is that indeed algorithms are able to, in the end up with the high prices, but that is not enough to prove that we have something close to collusion, because we need to identify these rewards and punishment elements associated with collusion. So let me just make a joke here. You know, being an economist, and especially a theoretical economist, is not great fun. So it's not super exciting job. But sometimes it happens that you discover something that really it's super fascinating and makes you literally jumping on the chair. This is literally what happened when we were studying these algorithms. And so let me show you the result. So you may have seen the graph that I'm showing you next, because it has been taken by some of the media that I was mentioning before. So what you see here is the strategies, the behavior that has been learned by two algorithms that were operating in one of our virtual markets. So there are two agents, two companies, two algorithms. Red and blue, they are at some point, after learning, they set high prices. So you have two lines here. The up green line is the monopolist pricing, so the highest meaningful price that companies may set in this market. The lowest bound is the competitive prices, which is not necessarily equal to marginal cost, because we are using differentiated products and many other variants. And then what you see is what these algorithms they've learned to do. Okay, so they set quite high price, not as high as a monopolist, but close. Now, so what we did is that, well, is this enough to claim that this is collusion? No. And by the way, there were some computer scientists that they did similar research that the one we did here, and I'm discussing here, in the 2000s, because these tools of artificial intelligence, they are not new. They are 30 years old. So they did some research, and they reached that conclusion, high prices. But then they stopped there. That's not enough. So we digged into what the algorithms have learned. And the way we did it was, for one period, we just forced one of the two algorithms to cut its price. Okay, this is what you see in the next point here. So the blue algorithm is taken by surprise. The red one is the one we forced in this period to cut its price. Okay, so that was us. And then we released the two algorithms to behave as they actually learned to do, autonomously. Okay, and this is the story. So the story is that they keep prices below for some time, very low, for some time, and then they gradually, but in a sense quickly, go back to the pre-shock very high prices that they were started with. So what you see here is precisely punishment and reward scheme. Okay, so for us this is a proof of concept that algorithms can learn to collude in the deep sense that we normally use both in economics and law. Now, I can also show you that the cartel that these two algorithms built, it's a stable cartel. So if you want to know whether our algorithm, the red one that we forced to cut its price, whether it got an extra profit out of that or not, this is the chart. You see that in the first period, these are profits. In the first period, the red algorithm gains a lot of profits. Okay, that's the gain of deviating from the cartel. But then you see that the profits are very much below for a significant number of periods after the deviation and when the punishment starts, in a way that systematically the deviation that we impose to the red algorithm is not profitable. So the cartel is intrinsically stable. So they learned to set up a cartel that is stable. Okay? So now, is this by chance? No, it's not by chance. We did tons of different variations, changing the market, changing the sophistication of the algorithms, entry, exit, stochastic demand, new entrants that come into the market and want to learn. And guess what? The two algorithms that already learned to set up a cartel, they teach to the incoming learning algorithm to join the cartel. So it's a stubborn result on collusion. And notice also that these algorithms, at least to us, they did not communicate. Okay, I say at least to us, to our understanding, is that we don't know exactly what is communication between algorithms, as was said before. So they may be able to communicate by, using details in prices in a way that we don't understand. By the way, you may be aware that Facebook had a very interesting project on algorithms, AI algorithms that were designed to bargain, to learn to bargain between each other. And apparently, they stopped the program, the activity, the research program, because they discovered that this algorithm, they have learned a communication, a new language that the researchers were not able to understand. And they shut down at least this is what they said, they shut down the research project. So learning is communication is an important topic. We don't know that much about this, and I think it's very important. So as I said, this does not prove that we have algorithmic collusion in markets. This does prove, at least to us, that is feasible, it's possible, it's not very complicated. It took us 2 years of research, but we are 4. Can you imagine large companies with hundreds of computer scientists? So it's not even comparable what we could do and what they can do. So my message here, I have some. So we also worked on policy implication. We have our view on policy, but I probably would like to keep this for further discussion later on. The message I want to give you at this point is that we are not doomed. We have some time to understand what is going on and to further research and further understand. And this is certainly an area where multidisciplinary investigation are not important, are necessary. It's the only way to go between economics, computer science, and lawyers and the law. So let me just tell you what we are doing. We're we are revising the papers for journals. That's what the academics do, but this is not fun. So we are studying other issues of coordination, which can be very important. There was some discussion also this morning. We think that a recommending system is something that we're working on. So imagine different recommending systems that in principle may be competing. Then they may learn that that's the best way is to recommend consumers on, I don't know, the preferred song, the preferred movie, the preferred product in a way to split the market. That would be a nice way to coordinate and avoid too much intense competition. What about dominance? Can algorithm learn to dominate markets? We don't know. So we are working on this. And another important thing is that learning can be manipulated. And this is somehow talking to policy. Learning can be manipulated. Imagine yourself when you were learning. Humans, they normally use a supervised learning approach together with a trial and error approach that algorithms are actually using mostly. We are very fragile when we learn how to behave. Algorithms as well are fragile when they learn. So manipulation of learning algorithm is something that is very interesting and potentially also in terms of policy, its policy implication. But I think I'd stop here.
Thank you very much. You raised both interesting questions, introduced some interesting results. I just want to quickly say, based on what you described, that computers have made us revise many of our old notions about what human beings are all about, what is thinking, what is communicating, what is it to be a friend, with social media and so on. And this is yet another example, and I want to just highlight this point that you raised for the audience going forward, that, how can we judge whether these two algorithms are communicating or it is a totally different thing? We have two options. Either we can say that we can stick to our old guns and, to our old notion of communication and think of communication as the exchange of language, right? Or exchange of symbols. Or alternatively, we can think about communication in a different way and broaden the notion of communication so that then now what these algorithms are doing can be potentially considered communication in the same way that, for instance, we are willing to allow to attribute communication to animals. Two birds, when they chirp, are they communicating? Well, if you ask some people, most people would say yes. Now, when the sunflower turns towards sun, because of the direction of radiation, is the sunflower communicating with the sun? Most people would say no. Cases like this fall somewhere in between, right? It is not totally mechanical, like the sunflower case, and it is not. There's no kind of intention behind it. There might not be any intention. Should that stop us from describing this as communication? So these are what I'm trying to say. These are the kinds of questions that we are facing in dealing with situations like this. So with that, let me introduce our next speaker. By the way, we had two other speakers on the panel who, because of other obligations, could not take part here. They are here, but they decided to opt out. So I'm moving directly to Dr. Pierre Horna, who is a legal affairs official at the Competition and Consumer Policies branch of UNCTAD. Is that how you say it? UNCTAD. Okay. Thank you.
Thank you very much, Hamid, and for that, and very nice to see you again. First of all, my thanks to Alexei and Maksim for the invitation on behalf of the Institute. Very happy to be here. UNCTAD stands for the United Nations Conference on Trade and Development, for those that are not familiar with my organization. And we are dealing with competition issues since 1980, where we had adopted, actually the member states of the United Nations adopted the UNCTAD on competition, which, by the way, is being renewed now next year in 2020, thanks to a very interesting proposal from the Russian government to strengthen international cooperation in the area of competition enforcement. So I'm happy to say a couple of words on this, since this is a very new step forward, I would say, in the area of competition law enforcement and international cooperation that also will address this problem of cartelization in the digital economy as a result of that. Happily to say that. I'm just very also enthusiastic to hear the presentation of Giacomo. I think your view as an economist is very illustrative. Also, I'm not an economist. I am a lawyer. So I will just say the other side of the coin regarding the word collusion, as you rightly said in your introductory remarks. We, meaning lawyers, have created this area of tacit collusion or collusion in the area of competition law as a way to extend the debate on how to understand the same phenomenon from different perspectives, an economist and a lawyer. I would say that conscious parallelism has actually implied the existence of collusion with a parallel conduct. And numerous jurisprudence from the EC competition law arena and other jurisdictions around the world have also looked at in this particular regard. This goes to the idea of what we have just seen in the previous presentation about algorithms can indeed trigger collusion and strengthen cartels, oligopolistic pricing. Now, the question of how to deal with this from the perspective of the vast majority of competition authorities in the world that represent younger or smaller competition authorities, it is a policy implication for the United Nations. It is a worry for the United Nations. And we try to, of course, look at from different perspectives. As a matter of fact, we are just finalizing a small research on this topic, which is precisely dealing with this problem. The research starts with a simple question. Should young enforcement competition authorities take active steps towards engaging with algorithm decision-making in order to deter the harmful effects of the digital cartelization and its resulting algorithm collusion, which, by the way, has been proved today? This question, or this simple question, of course, triggers us a number of problems. First of all, the area of ADM, or algorithm decision-making, brings up three different topics that have been developed differently over time. AI, big data, AI and big data differently, and, of course, the e-commerce, Internet of Things as well. So when we merge the three different aspects of this phenomenon, then you will end up having this type of problematic. As a result of that, we introduce this research, by the way, will be published very soon, from the perspective of the ADM being a double-edged sword. On the one hand, it can create many benefits from that perspective, particularly from the consumer protection side. It will create a lot of choice. It will automatize different types of services in many, many areas of the economy. At the same time, it will create some challenges for authorities. Now, since our interest in the UN, at least, is to deal with younger and smaller competition authorities or emerging authorities as well, we would like to understand whether or not this could be a priority area for these countries. What are the harmful effects that algorithm cartelization could bring to these markets in the developing world. So I just would like to talk about some of these particular areas. I have very little time, I know, but I just want to raise a couple of issues related to the point of deterring the harmful effects of algorithmic, in this area, cross-border cartelization. First, we talked about compliance and cooperation. This is an area where you have a number of competition authorities already working on this area. Happy to see that some of the BRICS authorities, particularly Russia, is taking a step forward on this assessment. But there are also other authorities representing the BRICS economies, like India, which is an active authority that it is prioritizing the digital market as a whole. Other authorities have actually looked at this from the perspective of paying more attention and allocating more resources to the prevention and investigation of monopolistic practices, cartel conduct in the digital markets. But one area that it's being explored, and as a matter of fact, in the recent ICN annual conference that took place in May this year, there was a session on precisely this topic, oligopolistic markets, cartels, and algorithms. And there was a common consensus that the way forward on this particular topic should be exploring more on areas related to compliance to companies. As you rightly said earlier, companies have the resources to look at them, to incubate, to sophisticatedly inspect algorithms. They have said that there should be compliance by design. And this is an area where in some BRICS emerging jurisdictions could actually be an interesting way forward. However, not in all countries that represent younger and smaller agencies. They also talk about the technical capabilities to closely monitor pricing algorithms and auditing or inspectioning these type of algorithms have been already mentioned as some measures to counteract this type of algorithm tacit collusion. But if we look at the offline world, where we have already this problem of tacit collusion and conscious parallelism, there were traditionally three main areas of work. The first one is about transparency of markets and how markets can be monitored by other competitors. The second point is are related to companies are capable of punishing deviators. We talked about punishing and rewards from the tacit agreement. But the most important one, to my point of view at least, is where the competitive constraints do not jeopardize the implementation of the common strategy. And that is one of the areas where we could have some challenges in saying that these algorithms by themselves can actually communicate to themselves. Perhaps in some experiments you can ascertain that. But to have a common strategy between these self-learning algorithms would be a challenging area for any younger or smaller competition authority to determine that. There's also this area of policy measures themselves. And we talked about cooperation. Yes, of course, cooperation, going back again to offline world, it is a problem in itself. You cannot always induce to cooperation if there are not common enforcement interests. Already, when it comes to the fight against international cartels in traditional sectors, talking about non-digital sectors, that raises a lot of problems to competition authorities, particularly the ones that are interacting between smaller and mature agencies. How can you induce cooperation between them if it's a more comprehensive and challenging problem that many of the mature agencies do not understand, really? They're still doing reports here and there. So this is a most challenging area, and we cannot take for granted that cooperation should take place in these problems. The strong institutions that we said earlier, an example of that is FAS from Russia, but also I have in my list other authorities. Younger authorities like the Philippines have recently announced to have a unit that deals with collusion and algorithms, which is very interesting, as well as India and Pakistan. There is also a further point about disciplined business and knowledge sharing between mature economies. I think that one area that could be explored is to have cooperation between this type of regional compliance programs that will allow, let's say, some of these regional and sub-regional settings to work together. The problem, of course, about algorithms itself, and one should be very clear on this, is that it's a very expensive undertaking. In some of these competition authorities, to just inspect an algorithm can take more than 10 to 15% of their total budget of the authority. And I have this data. I cannot say the country, but it's a young competition agency in the Asia Pacific. This might be very small for mature competition authorities, but not for those that are located in this type of regions. So we have proposed in our paper also to put forward additional ways and means to counteract this problem, like, for example, creating a regional algorithm incubator scheme that will help reduce the costs and increase the effectiveness at the regional or sub-regional level. And, of course, this would have economies of scale to understand the nature of these algorithms, that many of them are impacting at the sub-regional and regional basis. There are companies already in the Asia-Pacific region that are working on regional compliance programs related to algorithms. And particularly, they are coming from one BRICS region, which are very important, one BRICS country, and that could also be an example to continue. Finally, we just want to say that on the area of ADM and other processes, there are also other type of problems that could lead to further additional topics for these agencies. For example, the issue of blockchain that would transform market dynamics and competition. And, of course, in the relation to cartels and collusion, as well as the establishment of a distinctive regulatory framework that could encompass the differentiations at the same time of human and algorithm tacit collusion. One last word on this point is that we normally say that there are 4 different types of algorithms. The last one on self-learning might create problems because it doesn't really say on competition legislations that the meeting of minds will be triggered. But at the same time, it actually creates an opportunity, to our point of view, to further increase some type of cooperation. If we didn't do it from the area of the offline world, perhaps we can find an opportunity to work on this area, in particular for those that are more vulnerable in this process. Thank you very much.
Thank you, Pierre. I just want to highlight, the point that you raised, and basically on top of the earlier observation that even if algorithmic inspection was possible, it is too costly for organizations to implement, sometimes swallowing as much as 20% of their budget. And that's a very important consideration. So moving on to Filippo Maria Lancieri, GST candidate at the University of Chicago Law School.
Thank you very much, and thanks, of course, HSE and the HSE for hosting me here. I want to be, I think, a little bit contrarian. It's never fun to have a panel everybody agrees, so I'm going to do my role here as a Chicago person to tell Pierre that agencies should not be spending at all 20% of their budget on this topic, I think. I think that the main message I want to convey is that we need to to be much more cautious when you're thinking about this topic, in particular when you're thinking about translating this into policy making. So I'm not a traditional Chicago guy. I think that we are releasing today actually the Stigler reports, and we are proposing a lot of very big changes. Today is the consolidated report, just to explain that we're going to be out in some 9 hours when people in the US wake up. And we are proposing a range of policy changes to digital markets in general. But these, we had a 140-page report on dominance of digital markets. And there is a real reason why we focus on dominance. It's because the scholarship and the knowledge on dominance is just much more consolidated than the knowledge in this area. So since Rocher and Thiroux in 2003, we've been studying multi-sided markets and how these markets behave. So I think that while a contribution like Giacomo, they are incredibly important. I could not overestimate how important this is. And maybe in 10 years, Bjorn is going to be sitting in Sweden over there, is going to be listening to his contribution like Thiroux had, and then we're going to be listening. This is going to be awesome. I just think that they're just initial forays. They're proof of concepts in a field that we need way more better understanding before we start having actual policy changes. And I think there are three main reasons why this is the case. So first, most of the empirical data that I am aware of for markets that have been adopting algorithms for years show that coordination is much harder and the coordination is not actually taking place. So I'll give some stylized examples. These are very suggestive evidence. It's not definitive, but it shows that probably is much harder than the stylized models that we're seeing. So electricity markets in the US have been adopting algorithms for years, and the price of wholesale electricity has gone down, I think, 50% in the past decades. I think that airlines have been using algorithms for years as well, similar types of algorithms. And I was trying to look data for the EU, and I just saw the European Commission has a transportation area, and they were stressing how the price of air tickets between Paris and Milan dropped 16 times since 1992. So those prices now are 6% of what they were, let's say, 25 years ago. And this doesn't talk about changes in cost structures, doesn't talk about other things. That's definitely true for the US as well, where prices dropped more than 30% over the past decades. And they started going up a couple of years ago, but this is not correlated at all with algorithmic adoption. Actually, it's much more correlated with horrible merger policy that are allowing for concentration. And in particular, a lot of the parts of the gains of these companies come from ancillary revenues, so like bag fees and things like this, where it's much harder. There's no algorithmic collusion in bag fees. Like they're standardized, rather than they are into prices. And I have a colleague, we're actually discussing this over lunch, a PhD colleague of mine, who's actually doing work on this area, and this is doing the best empirical work that I know to date on this area. And he runs first a theoretical model, a Q-learning, reinforcement learning model like Giacomo's, and he uses prices, but he uses as well spare capacity. And his results are that once you add spare capacity, once you have two players, you have very quick collusion, but once you go to 3-4 players, this prices go down very fast. And so the moment that the algorithms becomes more complex, collusion becomes harder. And then he actually has empirical evidence. So he was looking for prices of flights leaving Chicago for, I think, 4 months, for all the flights leaving out of Chicago for 4 months. And he has very mixed results. So he finds that legacy carriers, they have stable prices, and they compete mostly among themselves. They don't compete with low-cost carriers. But he really finds that this stability and this correlation is really connected to concentration in the market. So the more players you have, the higher the correlation. And importantly, he finds no evidence of punishment, which is a key finding of all of these markets. And then I think that the most interesting research that I know, which is not connected to algorithms at all, but it's just suggestive evidence. So there's a professor in Chicago as well called Austin Goldsby, and he has a working paper with a guy called Klenow, and they look at inflation in the US comparing e-commerce markets versus regular markets. And they have a huge database for, I think, 1 million products, and their results are that inflation for e-commerce markets is 3% lower than inflation in actual retail per year from 2014 to 2017. So that's a huge number that you have. That's a market algorithms everywhere, and then these prices are much lower than they would be in real markets. So it's actually the opposite. They're showing a lot of rivalry, and so this is very suggestive evidence. It's not saying that the algorithmic collusion doesn't exist at all. It's just suggesting that it maybe is a bit harder than we would imagine. And then second thing, I think that cartel policy is very deterministic. So cartel policy is mostly per se or per object in most countries. You have almost no room to prove efficiencies, almost no room for defenses. They attack big and small players alike. Brazil has a famous case of a cartel of bakeries. The bakeries got condemned. And there's I think it's like the key textbook macroeconomics is like you can never have a cartel of bakeries in a city. And Brazil actually got a condemnation of a per se violation of bakeries in a small town outside of Brasilia. And they also have very high fines. And they have, in some countries like the US, they have criminal prosecution. So you're talking about a small company potentially adopting an algorithm that it doesn't really understand. And then you invert burdens of proof. The company doesn't really know how to defend, and then you have a small business owner going to jail. So that's a very, very big result that you can have that I think would award by itself thinking about whether academic discussions, which are extremely valuable and you should have, and how to translate that into policy. And then the third thing that I wanted to stress, and that's maybe a conjecture, I mean, that's really not my area at all, so maybe it's a conjecture, that maybe algorithmic collusion is easier to catch than regular cartels. If these prices are public and they are always available and people can just scrape data from Amazon, like you have these apps on Amazon that keep scraping data and showing how much price has changed for a product over 6 months, 10 months. And then looking at all the variations and saying like, oh, well, the price you're seeing right now is a little bit above or a little bit below the average price for this product for the past 2 months. So we actually have public data available, and then maybe authorities can start scraping this data in the future and then start looking, and then maybe catching algorithms the easier way than it would be for like very obscure markets where we don't have data on prices, we don't have historic data or anything like this. So I think that's a small intervention. I'm looking forward to the discussion. But I think that mostly that's all to point out that like we should think about this, because it's not that, of course, that people like to stress how like if you have a result like Giacomo and it improves into practice, it's a major loss. No, it's like if you have a 50% price increase over the competitive price, it's a gigantic loss. It's like these companies are appropriating a lot of rent they shouldn't be appropriating because of like some kind of illegal behavior. But if by changing defaults, if by starting to adopt policies that somehow do the opposite and disencourage companies from adopting algorithms, imagine that then you have the opposite effect. Imagine the size of consumer welfare laws is going to take place if companies that would move online and they would start adopting algorithms, would have increased rivalry, suddenly decide not to move online because policy is uncertain or because they don't know exactly what the algorithm is, they don't know what their responsibility is. And then instead of then you have a 3% loss, average loss for, I don't know, half of the economy. That's going to be gigantic as well. So I think that the message I wanted to convey, and I look forward to discussing, is that like, so the question is like, should small agencies or even large agencies be prioritizing this? I think no. I think agencies are overstretched. They have a lot of work to do. They have a lot of work to do in digital markets that we've been discussing, like a lot of dominance areas with like Google and Facebook and a lot of problems we have in this market. They would be much better off focusing their scarce resources against these companies, against other types of behavior that they would be prosecuting right now, or starting to think about the prosecution of algorithmic collusion. So that's what I wanted to say. Thank you.
Okay, thanks, Pierre, for that healthy skepticism or Chicago skepticism. There's a lot to be talked about. Hopefully we'll have the chance during the conversation about consumer welfare and so on. But just on a personal level and anecdotal, you mentioned Milan, and what route was that? That was
16. It dropped 16. Like
between Milan and Sombor.
Yeah, it's like 6% of the price.
Having lived in the U.S. for almost 25 years, I've noticed that the airfare prices have significantly gone up in the routes that I travel.
I think that over the past couple of years they've gone up. So that's also the data shows that they used to go down, and then once they started approving like all this, like there was a huge consolidation that took place, and then after that prices started going up a lot. So I think I'm not praising U.S. airlines. I think that's mostly they're expensive and they provide a very bad service in general. I'm just saying that like
I do like dynamic pricing by my bakery. Yes, when they drop the price by half in the afternoon. But I'm not sure if I like the dynamic pricing by the airlines. But I'm just trying to be provocative here so that we can have a good conversation afterwards. Okay, last but not least is Avirup Bose, Associate Professor and Assistant Director of Center for International Trade and Economic Laws at Jindal Global Law School.
Thank you, Professor Hamid. Thank you, Alexei. Thank you, Yanis, for having us. And, of course, Maksim, without whom I think we could not be here physically. But Being the last speaker on an illustrious panel like this almost makes me feel like, one of the later wives of Henry VIII. You know what is expected out of you, you just don't know how to get there. So I'll try to change a bit as to what I thought I would speak. I was lucky to be a part of the report where I have kind of documented, the Indian jurisprudence on these topics, but I'll not repeat that. The report is coming out tomorrow, so hopefully people will be able to read it. I'll begin with two cases in India that has happened in India, and then try to relate it to the larger BRICS perspective. Because every panel has talked about Uber, I thought that I'll also use that same example. The first case is the decision was released by the Competition Commission of India in November 2018, so it's like a year old, where there was an allegation that was made by a private user against Uber and Ola. They are the two leading taxi aggregator apps of India, about sort of algorithmic price fixing within a hub and spoke sort of a context, where the allegation was that the drivers and the users, the passengers, the price was being set by an algorithm, and that was allowing to have a hub and spoke sort of price setting conspiracy or a price setting arrangement, and people were not being able to sort of take advantage of a negotiated price. The Commission kind of threw this case out, kind of saying in a very prima facie sort of analysis that the drivers are acceding to a set price by an algorithm that doesn't amount to price collusion. Now, this was a lost opportunity, I believe, because of a lot of conversations which Professor Hamid was trying to mention about what is the understanding of collusion within the context of algorithmic price fixing. And now, there could be two ways in which you could have, apart from an actual conspiracy, many of us are familiar with the 2015 FTC sort of successful prosecution about price fixing, algorithmic price fixing. This was with respect to somebody who was selling posters on Amazon, if I remember correctly. You could have a scenario which the chair was mentioning where, individual users of an industry sync their algorithm to to certain sort of similar industry pricing policies, and you kind of arrive at a price equilibrium without necessarily colluding. On the other hand, you have autonomous algorithms which can do this completely by themselves. Fortunately or unfortunately, under the cartel provisions of India, there are several categories. There is, I'm not going into the legal definitions of each of them. So there is agreement, arrangement, tacit collusion, and there's this new innovative term which they have put in there called practices carried on, which essentially means that it doesn't matter whether you actually collude, you actually have intended, but whether you are carrying on a practice which amounts to a collusive behavior. The reason I'm saying it's a lost opportunity because you could have somewhat of a jurisprudence coming out of the Commission as to whether algorithms which reach a particular pricing paradigm without necessarily speaking to each other can come under this innovative term, practice carried on, which interestingly brings me to the topic of algorithmic inspection, which I think you're referring to Professor Danny Sokol's sort of paper, where you can literally, as far as my country is concerned, shift the burden upon algorithmic inspection on the companies, because no matter if there is an algorithmic collusion without intention, you can have a prosecution of those companies. But that story did not happen. Now, the story that did happen, and I will spend the rest of my time discussing that, was a decision that came out of the Supreme Court of India, why that's the reason it's relevant, on how Uber charges its, sort of undercuts its price, and what that relates to within the concept of predatory pricing. The Competition Commission of India earlier had dismissed a case against Uber for predatory pricing on the assumption that there was a healthy competition between both the taxi-hailing apps, and as long as you do not enjoy a dominant position, there is no question of abuse of dominance through a predatory pricing tactic. The Indian Supreme Court last month has thrown out that analysis and has now directed the Competition Commission within 6 months to come out with its analysis of predatory pricing of Uber. Now, why is it interesting? Is because India has this term called unfair price within its category of predatory price. What it says is that a price could be either predatory or it could be either unfair. Now, within the logic or within the concept of pricing on platforms, pricing through algorithmic collusion or otherwise, to what extent can competition agencies like India prosecute companies based upon unfair price is something that I found very interesting. I think one of the topics that was raised that one of the primary aim of an algorithm is to maximize profit. So, for example, it wants to charge a surge price when to figure out the economy when surge prices are feasible in terms of a demand and a supply relationship. But let's say the same surge price can be a completely unfair price within this analysis of the Supreme Court of my country. Now, when again, the decision hasn't come out, but then I started looking at some of the other BRICS countries. And I kind of found, and I'm sorry, I know there are experts from other countries here, so please forgive me if I mention a law that is no longer valid or changes have been made, but this is an initial research of mine. So I looked at a few of the other countries to figure out what their jurisdictions talks about unfair price as a subset of pricing abuse or exploitatory abuse. So I'm looking at Article 17 of China's anti-monopoly law. It says it prohibits selling commodities at unfairly high price or buying commodities at unfairly low price. Of course, there are a lot of cases and analysis. I'm not going into those, but there is kind of jurisprudence there where unfair price itself could be an exploitative abuse. South Korea, Article 321 of the Monopoly Regulation and Fair Trade Act, again, has a terminology says unfairly supplying or purchasing goods or services at lower or higher prices than arm's length price, thereby likely to excluding competitor business entities. Now, to what extent is an arm's length price within the algorithmic space is something that can be an issue of prosecution before these courts. The Korean Supreme Court has actually given a list of factors. I'll not go through all of those factors, but there are two things which is interesting in this factor. One of the factors, this is again for unfair price, is changes of price and output within the relevant markets. If the price is fluctuating within a relevant market, might be based upon algorithmic inputs, it could amount to an abusive practice. Interference with innovation and reduction of diversity. Now, there was an argument made before the Indian Supreme Court that Meru, which was the complainant in the case, is not a taxi aggregator app. It is a transportation company. It basically registered taxis and sort of plays within the transportation business. So it is subjected to a heavy set of regulations which a taxi hailing app is not subjected to. Because of its limitations, it cannot attract a lot of FDI. Okay? So one of the concept of diversity within firms was brought in within the courts. To what extent is a well-resourced firm is capable of doing predatory pricing as opposed to a less resourceful firm. And within this analysis, people talked about the concept of an unfair price being charged on a smaller player as opposed to a larger player. South Africa, Section 8A of the South African Competition Act, again has an understanding of excessive price. There has been courts' decisions which has talked about what is the economic value as opposed to what is a fair value of a price. And if I am not mistaken, there was a bill that was introduced in 2018, I do not know whether that has come into force, where a prima facie case of abuse of dominance could be charged on a standalone basis on questions of unfair price. Lastly, Article 36 of the Brazilian competition law also has a restriction on arbitrarily increasing profits based upon by a dominant company. And in a case, Sindimiva versus White Industries, the Brazilian Competition Authority, with a very narrow vote to margin, it's 4-3 votes, it said that a price which is excessive could be an exploitative price itself. So I know I went through a lot of these provisions, maybe I can pass on my notes. Again, this is something that I'm developing. This is a research topic. The area of my interest was something that I think Paolo mentioned in the first session, not only how firms compete in the digital age has become interesting. It's how firms or platforms price their products could become very interesting. Whether prices that is engineered out of an autonomous algorithm, can it have abuse of dominance implications? The Indian Supreme Court, again, it's an interim order, it's not a final order, thinks it can. Some of these provisions that I kind of looked into, again, many of them are not with respect to new industries, many of them are cases dealing with traditional industries, kind of have a subset of unfair price. So that's something that I wanted to explore more. To what extent is an economic value of a product abusive or exploited compared to a fair value of the same product? Thank you.
All right. Thank you very much. Let's open this to questions and discussion. Yes, Karliuk, right? Yes, go ahead.
Just one very quick question to Giacomo. As a microtheorist, I'm sure you did this. I'm just curious, since I didn't see the results. As the number of players increases, do you get closer to Nash equilibrium profits? Yeah? Okay. And if that's true, then how much of a concern is algorithmic collusion? If you allow enough algorithms, then there may not be collusion.
Yeah, so you are perfectly right. As the number of algorithms increase, price reduces. That's economic theory. We're happy with that. We were super happy to have this in the data because it means that what we are showing is meaningful in terms of economic results. If we have markets with hundreds of firms, no problem. But there are markets in which we have a couple, 3, 4, 5, 6 firms. We have tested up to 4 firms, and we still obtain 50% extra prices, super competitive prices, which is enormous.
Yeah. First, a short comment. We are talking about digital markets, but here in this session actually we have something a little bit different. It seems to be the effect of digital markets in traditional markets. So it's the pricing strategy of traditional markets like airline companies that are affected, that are now digital and may be affected by the algorithms. But having said that, I think we agree that we may have collusion in the market, but not necessarily antitrust offense. I mean, tacit collusion is not considered an antitrust offense, and explicit collusion would be an antitrust offense. So the discussion now is how to differentiate tacit collusion and explicit collusion. Actually, it's not that easy. We have some examples. There is an interesting paper on spectrum collusion in FCC auctions. And companies were found guilty because they communicated by the bids. So the bids have the information about how the punishment was enforced. And so the thing that we have now, can you have a similar interpretation that companies are communicating by their pricing strategies? And if that's the case, perhaps we have more a blurred differentiation between what is tacit collusion and what is explicit collusion.
Again, American antitrust has this quite a robust literature on price signaling within the antitrust paradigm. There could be instances when, especially in oligopolistic markets, where you could signal price through bids, through speeches given at conferences and all of that. But again, I don't think I've come across any jurisdiction which has successfully prosecuted a cartel only on grounds of these kind of tacit collusion, which operates at that level of which cannot have some sort of more concrete conduct or economic evidence in terms of how they actually colluded in meeting of minds. So it's very interesting if something of the same lines could be developed for artificial intelligence, for algorithms, which brings back to our question of how to define communication here.
I agree. That's the point. How to define communication. So our algorithms, they had no tools to communicate. So the only leverage they could use was prices. And they reached an agreement through varying the prices. So one could also say that they were communicating with prices. So by trying prices, by showing the other algorithm to be ready to try different prices and to react in different ways, they could be communicating that way. So we need a better interpretation of what communication is, what is the language, what is the vocabulary that we use for our language. As I was mentioning before, Facebook, they had this research, and the algorithms, they were using a completely new language, so just mixing letters together, and they were able to tell each other what to do in this bargaining process. So, yeah, that's very important and interesting.
Yes, go ahead. No, I think just to complement, it has been a long time since I read the case, but I think that the airline cartel is actually a similar story. It's like the airlines, they use pricing algorithms, but in this case, they actually used a system of signaling. So what they did is that they just they said I'm going to raise the price in 3 days, and then they would wait to see if the competitors would follow or not. And then when the competitors didn't follow, they would not raise the prices, and if they would follow, then they would raise the price. And then this was found a cartel. And there's actually if I remember correctly, Kai's going to remember, in the Brazilian case, there was a very interesting discussion because one of the companies then claimed price leadership. He said, I'm just following the leader. And then there was a discussion on whether the changes in price was 50 minutes, and then the discussion was if he's only following the leader, then how long would it take for a person to see the thing? And then run into the manager, tell the manager that the price had been raised, and then run back and then implement. And then the other commissioner was saying, well, what if he called him? And it was this crazy discussion saying, at what point do you separate just price leadership from regular, from actually signaling and then this being deemed an agreement? But I think another thing that's interesting to know is that if you assume that these algorithms are not communicating at all in the sense there's no concrete communication, if you kind of invert a burden of proof and put the burden on the companies to show that their algorithms did not collude, but the companies only have their own information, I cannot really understand what could they argue in their own defense. Would they need to be checking the market all the time and make sure that if their price ever meets the price of their competitor, someone has to go there and press a button saying lower it by 10%, and then go back, and then the guy just stays there looking because they're going to collude again, and they press the button again. And then I don't really understand what exactly this new cartel policy would look like. If what exactly would this compliance mean? I would actually love to hear from you, because it's not from other panelists.
I don't want to monopolize the discussion. Exactly. So I didn't discuss and express myself in terms of policy. Let me just spend a few words, because we thought about this, what to do in terms of policy, and I think I agree on several things that have been said. Before that, let me also rebut a few things that Filippo said. So there are two classes of learning algorithms. We know there are two classes, broadly speaking. One is passive learning, another one is active learning. The active learning class is what we use and what AI is actually using. Active means that the algorithm actively explores and experiments the environment. This is the type of algorithm AI uses and we use. And another class of algorithms that is already used and has been used for decades in the industry is passive learning, which means that you simply, quote unquote, collect data from the market, you feed your knowledge from this data, and you find the best feedback to this data. This is passive learning. It's learning because you are taking data, collecting data from the market, and you adapt yourself to this information. So energy sector works like that. Some financial markets work like that. Electricity works like that. There are theoretical results showing that this passive learning algorithms must converge to Nash equilibrium. So it's not a surprise that some of these markets are fairly competitive and not collusive because they're using this class of algorithms. So what we are doing here, we're really shifting the paradigm of the algorithms that we are studying in a different way. Also, capacity constraint. We haven't done the capacity constraint exercise, so your colleague is doing some very nice job. But we did something very similar, which is exogenous entry and exit of some firms in the market, which is happen when you exhaust your capacity, you exit temporarily the market. So strategically, it should be very similar. And we observe that the price, super competitive prices are lower than without entry and exit, but still 30% higher than competitive price, which is a lot, as I said before. No? So we must act on that. So in terms of policy, 1 minute. What we have learned that there is no way to inspect and to understand fully these algorithms. There is no way. So our algorithms are simple. Now we are struggling for the editors of journals to explain exactly what strategies they've learned. What I just showed you is a piece of strategy of what they learned, but the strategy is much more complex, and they want us to explain exactly what the strategy is. It's very complicated. It's unfeasible to explain. And this is a simple algorithm. Not talking about deep learning. Neural networks, they don't have a human interpretability. There is no way to interpret the behavior. Actually, that's the trick. The trick for us is moving from intentions. There is no way to understand intention if anything makes sense in terms of intentions and algorithms. From intentions, that is the key ingredients in cartel and antitrust activities, to behavior. What we don't want to see is the behavior I was showing you before in market. We don't want to have algorithms like that have learned that behavior. We can, in terms of a policy, let's say, paradigm shift, we can think about moving from intentions to behavior. Behavior we can check. Okay, because exactly you can take an algorithm that is currently used by companies in market and you can test it, what behavior has learned, and a manager can do. A manager, if we just simply use this idea, for example, I have heard thinking about algorithm as a facilitating practice. That would be a disaster. That would be a chilling effect in the market. No managers would use ever AI for pricing. It would be a loss of efficiency. Okay? So instead of going that way, managers could be responsible of checking that their algorithms, they don't behave the way we just saw in terms of reward and punishment. We think it's not very complicated and very difficult to do.
And again, also you often have people who you use third-party algorithms, or data which is being used in a particular manner, which is available to other suppliers. So, the people who it's not a very if algorithm inspection. I don't think the suggestion is to kind of check proprietary, completely autonomous deep learning algorithms. Whereas there could be other types of algorithms where you can check the effect of how the inputs that you're feeding into the algorithm has an effect on the market. That can be checked, which is not an autonomous sort of deep learning algorithm.
You have to cover?
Just two questions. One is, I understand the problem of thinking about intentions when we're talking about algorithms, but moving towards behavior, that seems something that we have been avoiding, especially when that behavior would be rational for economic agents that did not communicate among themselves, right? So if you lead to tacit collusion in a oligopolistic market, and that's an above competitive price, that's the equilibrium, we would not punish it in most jurisdictions. There would be no illegal conduct there. So the question is, why to make that illegal in an algorithm type of decision? And I can see a way of thinking that way if you think that you can embed in the design of the algorithm something that's better than what humans would do and could obliged somehow to adopt that. Maybe that could be a reason for that. But I wonder how an economist that would probably agree with the first statement would deal with that, and why you would shift there. And then just one additional issue that I really don't understand, and it would be great if you could clarify. That is there any way in these learning, especially the active learning algorithms, for embedding some restrictions in these learning when you were building the algorithms? Because I saw at least a few policymakers, including Margaret Vestager, asking for, or at least creating responsibility for those that are building the algorithms, that they should embed, and it's almost compliance by design here, that you should embed in the design of the algorithm. But I'm not sure if it works for deep learning.
Good questions. Let's get a couple of other questions. Yeah. So, Nicola, go ahead.
Mine actually follows nicely from that. So I do think that it makes sense to identify areas where we want to say no, that the input cannot be given in such a way that, for example, the algorithm mirrors the prices of competitors. So there are some areas where, we're not required to inspect, because we have this understanding that we want to stop collusion from the incipiency. So in law, we use presumptions when we are quite certain that this is going to happen, so we draw a line. But how far do we want to carry this? Actually, there's a nice example that I read recently in the news where Uber drivers, to connect to what you were discussing, discovered that if they switch off altogether Uber algorithm, then the prices, when they switch it on again all together, then it would be higher. So it would be surge pricing. So would we also require algorithmic, services provider to make sure that the algorithm not only doesn't collude in itself, but prevents humans from manipulating it in a way that reaches collusion? That's a step beyond, which I'm not sure whether we are equipped. We are ready now to face. So that's how do you think about this kind of issues?
Thank you, Alexei.
Thanks. I have just two short questions. One is related to this evidence aspect of this collusion. It's often we hear that basically on one side there is a digital footprint which we can collect and then prove on the basis of this. So it makes it easier to prove collusion actually in this digital context. On another side, as I understand, and correct me if I'm wrong, that basically you can design algorithm in a way that it would pretend not to collude, so making some, intentional errors or illogical, things which would just show, like in the court, look, we didn't collude here. See here, we had different pricing here and there. So basically, create artificially illusion of, organic price making. How to beat this? How to basically address to this? If we understand that authorities can't catch up with companies. In a sense, companies have more engineers. And this one also relates to the topic Pierre raised, like smaller authorities, how they have to do in the modern world. So my question is, would you say this digital divide we have in terms of capacity for authorities, whether it can actually encourage authorities to cooperate more in terms of capacity building, like maybe joint digital systems, whether it could be authorities colluding against colluders, in digital age, and whether it's feasible idea, basically, to build like supercomputers for authorities becoming digital themselves. Second, whether it's possible to build, because if you invest state funding, let's say, to build capacity for authorities to deal with digital collusion, so then it's possible to allocate enough funds to build like really good digital tools to basically catch these guys. And whether if it would be even international cooperation, then it would be even more efficient. So whether you think this is possible, whether this is going to be moving this direction, or it's basically nonsense and utopia. Okay.
It's not particularly algorithms, but Avirup talked about unfair price. In traditional economic theory, there's no such thing as unfair pricing. It's more of a competition economics thing that if there is excessive markup, it's called unfair price. So how do competition authorities decide? It's kind of arbitrary. What is unfair price, and how do they decide what's fair price? How do they deal with these cases?
Yes, go ahead.
So my question will really build on what Alexei was saying, and in terms of cooperation, it seems that increasingly collusion problems and algorithmic collusion is of relevance for public procurement. And in some jurisdictions, like in Russia, FAS is dealing with both, with competition policy and with public procurement to a certain extent. But in some jurisdictions, these two areas are divided. So what we see actually that agencies which are dealing with public procurement, they are not really in touch with what competition agencies are doing. So my point being, for policy dimension, it's very good to cooperate regionally, internally, internationally, but as well there are some issues to be addressed on national level. Then if we talk about building such digital system to address these issues, that such an important sector as public procurement is being taken into account.
Well, first of all, I would like to say that when we talk about this type of topics, it is very important to differentiate between the area of cartels and abuse of dominance. I think in the particular part of the digital area, even without actually talking about digital area, many younger and smaller competition authorities try to look at the area of cartels, even because in many of these jurisdictions it's a bit easier to understand the effects of the markets. But also because in those jurisdictions would be easier to look at specific cases that go directly to public citizens' scrutiny. So I don't think directly that the majority of these authorities would actually see that whether or not a cartelization that is coming from an offline or online world, as long as it has a very important impact to their economy, they will intervene. So that's one thing. And second thing is about the area of international cartels. So it is a totally different monster to understand international cartels and abuse of dominant positions, even the area of mergers. So I think international cooperation should be tailor-made to this type of activities. We cannot mix approaches on this because every single area has its own problematic. When it comes to international cartels, the ICN, OECD, and us, UNCTAD, have looked at from a different way than unilateral conduct and as well as mergers. So we cannot really take it very superficially, these areas. Now, the second point is that when we discuss the challenges of this particular panel of today, it's about collusion. We are bringing about areas that already been discussed without the area of the digital economy. We're talking about tacit versus express collusion. We're talking about how to differentiate between areas where we can actually prove directly that there has been a conscious parallelism. So if we want to look at from the perspective of how algorithms will actually easier the analysis or make it more complex, that's precisely how this research that has been presented earlier would actually provide some lights. When we talked about the reality of younger agencies and smaller economies, I just want to refresh the memory for those that were in the ICN annual conference in Cartagena this year, there was a session on this precisely, on younger agencies, on younger and smaller agencies. And there was a report that was updated from 2006 by the Mexican Competition Authority. And what are the findings of this report? Precisely that as we have these smaller authorities that have coming from very, very specific jurisdictions, that are not necessarily authorities that may have all the expertise, but they are catching up very quickly, the main challenge would be how to deal with areas that are already impacting their citizens in the area of the digital economy. So they cannot turn a blind eye to this situation by saying that we have other priorities, because the priorities is also triggered by the public scrutiny and the legitimacy and the national constitution they might have. Already an authority from a very small country in the Pacific Islands was saying that this is a problem for them. So we cannot relativize and make presumptions that might not be realistic in these countries. But it is true as well that there is a lack of technical expertise. There is, of course, a lack of political will also in many of these authorities. And I would say that the funding would be a very specific challenge. Now, when we talk about technical assistance in many ways address this problem. They are the typical way of assisting a country that has needs, and there's also a very more different contemporary ways of doing it. In the UN, of course, we do both ways. We are trying to innovate more with partnerships, but the first part we do is to actually make sure that the country has already the political will to undertake this type of activities. I was just some time ago at the end of July in the Philippines, and they asked me to prepare a small presentation on this topic. And the first question they asked me, and this is a very young authority, this has no more than 2 years old, 3 years old, 2016, 1st of January, they started to work, the Philippine Competition Authority. And there, the first question they asked me is whether this could be a comprehensive assistance, not one show, one-stop event, whether you can provide a comprehensive of a 5-year program assistance to the authority without actually looking at the tip of the iceberg, but the whole area of, for example, in this case, advocacy in the digital economy. So they already prioritized this area because it is important, but digital economy is a vast point. It's not only about cartelization, it's not about algorithms, it's many of these areas. So one of these topics that is the one that we're discussing today, of course, has triggered already to this younger authority and very young authority a very important question mark. What do we do if we find this type of situation? And the first thing they would follow is what others are doing. So what other competition authorities are doing it. And if they don't find answers, then they will look at this international mainstreaming of policy makers. For example, the ICN. They would say, well, what the ICN has said recently on this. Okay, it is true. They have come up with this idea of going with more compliance by design to shift the burden to the private sector, to the companies that are really producing it and create a specific type of compliance that would discipline them in a more effective way. But would it be a realistic situation or solution to this particular jurisdiction or to the bunch of authorities that have the same problem? Because it's not only Philippines. There are also other authorities in that particular region that are doing the same, that are facing the same problem. So I would say that including, of course, a very important jurisdiction like Indonesia, so which is also actually facing this problem. So I would say that for the perspective of the policy and the technical expertise, cost knowledge would definitely jeopardize if there's no strategic point of view of these authorities that can actually burden the costs, and they can also work together with some of these companies that already has some expertise on this topic. And of course, when we talk about liability, that has been already raised earlier, we cannot go back to the 90s when we say that this would be resulted by tort law or by any type of liability of the software author or software manager, because that will be going back to 20 or 30 years ago. I think we need to find a different solution, and more or less what we have here in terms of having this proactive approach with this incubation of algorithms can be an interesting solution.
Thank you, Pierre. One question was asked: to what extent can sort of algorithms have checks and balances within themselves? I think, or if they can be designed to have certain mock. One of the biggest problems that at least I have seen is that whether young or old, many of the authorities, when they come across with these solutions, they have hardly consulted. They hardly have the technical consultation on board before they actually make these kind of suggestions whether you can. I do not know exactly whether the European Union before the Commissioner made those statements, whether they did some market survey to figure out whether certain kind of triggers can be sort of brought into the effective functioning of an algorithm. So going back to the question that I think Garima raised with what respect to unfair price, that's a problem as far as platform markets are concerned, because unfair price is something which is, again, the authorities, at least in my research shows, they can come up with their own parameters of judging what an unfair price is, and often a price is unfair not on the basis of the price you're charging, but it is often pegged against the ability of your competitor to compete at that price. Now, a lot of the factors that a particular platform allow you to charge a price, or the particular sector, the segment of the industry allows you to charge, that gets ignored in the analysis, which is very problematic from the point of view of platforms, because as somebody was mentioning, you're introducing these markets into more traditional sectors where pricing could be done understood in a very different manner. So there is no clarity as to how an unfair price kind of is sort of judged.
Others? Yes, go ahead. There were a couple of comments. So let me just count the countries that, at least to my knowledge at this point, are working, so the authorities that are working. I was aware of Germany, France, UK, now I just heard Pakistan, India, Philippines. I think here international coordination is essential. They are trying to do exactly the same thing. So it really doesn't make sense to duplicate this effort. So here I think UN and ICN have a very important role to play, and groups like BRICS. I really think it makes a lot of sense to put together, force it together. Restricting algorithms, or in order to have compliance by design, I think it's a very tricky way to go, because we should really leave computer science to go ahead and think anew, and we should not restrict or tie their hands. We don't know. So actually, I don't know. I spent 2 years working on here, and I can tell you I'm continuously checking the research on computer science every week. 15 to 20 new articles with variants of algorithms every week. There is no way. So let them do their work. That's why I think behavior, it's a move of paradigm. I totally agree with you. So let's move away from intention. What the behavior I was showing you in the previous slides has nothing to do with competition. You cannot misinterpret in terms of competition. And what is interesting here is that you cannot test a manager, the intentions of a manager. You ask a manager, are you ready to reward and punish? Of course not. If you can test an algorithm, you can subpoena an algorithm and test and have a test bed environment for an algorithm, do exactly this type of exercise. I'm not claiming it's simple. This move from intention to behavior is not simple, also because we don't know we don't have full understanding of what is a colluding behavior. That, to me, is clear, but it could be much more sophisticated, and we haven't investigated. Economists haven't done, so we don't have empirical research on this, and we don't have good theories yet. So I'm talking about my profession. But I think it's an interesting way to go.
So I have refrained to share my views on this because I'm a moderator. If you don't mind, I want to just use 1 minute, because I think I agree that moving from intention to behavior is a good move. I think we have to even go beyond that, not behavior, because behavior is also, as you said, complex. Why not the outcome? Go and move from behavior to outcome. See what the outcomes of these kinds of arrangements are. And some of you might remember at the legal forum, back in 2018, we had a conversation about this. The Chicago boys are as much responsible about this as everybody else in terms of the focus of antitrust law, consumer welfare, and so on. Has not been the case for too long. It's just 20, 30, 40 years old. But before that, the focus, at least in the U.S. law, was on small businesses and competitiveness and so on and so forth. So you can going back to your point, I was the one initially to set maybe this up, and now I regret it, because from the fact that algorithms are this complex and it is difficult to understand them, we should not necessarily conclude that we should throw our hands up and let them do their job. Innovation is one thing, and I agree with my colleague here. But oftentimes the complexity of these systems is used as an excuse by human agencies behind them, by firms, corporations, and so on, to justify their behavior. So I think it's very simple. Yes, it is complex. Yes, it is difficult to understand what they are doing. But from that, we shouldn't come to the conclusion that human beings do not have any responsibility. I mean, by human beings, I mean firms and corporations and governments and so on and so forth. So it would be, I think, it's a very treacherous kind of ground for us to get, and that is something that is used not only in competition, in other areas such as warfare, for instance. Autonomous weapons are used as an excuse to remove responsibility from human agency and put it on the shoulder of the machines. And we don't want to do the same thing here. So it's the commonality among all of this is that it has become a kind of fashionable to use the power of machines to justify bad human decision or bad human behavior. That's as far as this. I mean, in my humble opinion, or not so humble opinion, that is the bottom line of this. So I agree with you that So in a sense, what I'm suggesting is that let's go beyond and behind this, and think about this more broadly rather than just what the machines can do. This is, I think, somewhere maybe in between Filippo and you, or maybe somewhere else. I don't know. I just needed to say that because I set up the argument maybe in a way that might lead some of us to that conclusion. I apologize for taking your time, but Filippo, go ahead.
Well, I'll just make a small comment not related to this. Another question was about price, like excessive pricing, and I think that's a horrible idea. Like, sector regulators do a very bad job fixing price in the electricity market, and they are specialized. They have 1,000 employees who only do this. If you allow antitrust regulators to have control over the entire economy, this seems even worse. And a new trend that was started by Germany, which is using antitrust to control data prices, then it's going to be I won't even comment because I think the worst idea you can have, but that's just to make a...
I would like to refer to the question, to the issue raised by the representative from World Trade Organization. So this issue concerns to the effective cooperation between competition authorities and other public authorities which are responsible for public procurement process. So here we are discussing the price collusion issues, right? And as we know from our experience, price collusions very often happen in public procurement processes. However, very often competition authorities they don't have appropriate access to this information, as they are responsible for competition issues, and in all the countries, other public agencies are responsible for a public procurement process. For example, in Russia, the experience is different. Federal Anti-Monopoly Service is responsible for both directions, for competition issues and for a public procurement process. However, in many other countries, so those the jurisdictions are separated, those jurisdictions are distinguished, and this creates a big problem for competition authorities. I would like to bring my experience. I have been working in the Armenian Competition Authority for many years. So we were dealing with competition issues. However, we had very constrained access to the data on public procurement process. And competition authorities are getting this information when they are dealing with complaints. Otherwise, it is not possible, as this information on public procurement process mainly belongs to the public bodies, to Ministry of Finance, to other public agencies, governmental agencies, which are responsible for the regulation and for the supervision of public procurement process. Otherwise, competition authorities, they don't have appropriate and effective access to the data on public procurement process, on collusions, etc. So I would like to stress this evidence that this is very actual problem. The cooperation between competition authorities and governmental agencies which are responsible for public procurement process.
Thank you very much. With that comment, let's thank our panel for the